This is the Registered Behavior Technician course presented by Shaza Attar. The course content was created by Shaza Attar and is the property of Autism Therapy and Training, Inc. All rights are reserved. This training program is based on the Behavior Analyst Certification Board 2018 RBT Task List 2nd edition and is designed to meet the 40-hour training requirement for the RBT credential. The program is offered independent of the BACB. Remember, in each class, we will have our active listening, a quiz, and a competency assessment. Hi everyone, welcome to our class on complying with applicable legal, regulatory, and workplace data collection, storage, transportation, and documentation requirements. Now that's a mouthful. What are you required to do with documents, and why is it so important to worry about documentation? You may think to yourself, well, my job is to work with the client and ensure that they are safe and learning, and move on. But there is a great deal of writing down what happens, and keeping those records is really important. You'll be documenting things like ABCs, session notes, data, programs. You may have a report that your supervisor has written about the client on hand. You may have a psychological assessment that you have received from a third party on file. But we also need to consider documents with your team as well. For example, your logs that track your hours or meeting minutes and things like that are valuable and must be maintained as well. This information needs to be protected, stored properly, destroyed properly. So this course will go through this information based on the BACB requirements, but what's important to note here is you need to know what is the legal requirement in your country, state, or province. Now, I'm not a legal expert, so it is advised that you have a lawyer that you can also go back to and discuss any legal concerns you may have. Or the organization you work at has a lawyer or they know of the rules. Be sure you get that information for your own knowledge. It's crucial that you know and you learn it so that you don't accidentally violate any legal requirements. For example, suppose you worked at an organization and they asked you to speak to a group about autism, and they wanted you to talk about a specific client of yours. You state their name, age, the school they go to, who their parents are, their diagnosis, medical history, and so on. Is that okay? What if someone in the group was listening in and identified the family, and you got sued? Who's at fault here? Is it your organization, you, or both? How will that impact you and your practice? So knowing the law is important so that you don't break the law and privacy of your client. I want to review PIPEDA, HIPAA, and the BACB requirements regarding collecting, storing, transporting, and documenting requirements. Let's get started. What is PIPEDA? It is Personal Information Protection and Electronic Documents Act of Canada. It's a Canadian law relating to data privacy. It governs how private sector organizations collect, use, and disclose personal information in the course of commercial business. In Canada, PIPEDA applies to all personal data and health information. Once you collect data or information about someone, regardless of the province, industry, you and the organization are now fully accountable and responsible for the protection of that information. Not all aspects of PIPEDA apply to every province, so you need to know the differences based on the province you are in. Each province may have its own variation of PIPEDA, as long as it's similar to the actual rules and regulations. PIPEDA became a law in 2000. In addition, the Act contains various provisions to facilitate the use of electronic documents. The law gives individuals the right to know why an organization collects, uses, or discloses their personal information. Expect an organization to collect, use, or disclose their personal information reasonably and appropriately, and not to use the information for any purpose other than that to which you have consented. Know who in the organization is responsible for protecting their personal information. Expect an organization to protect their personal information by taking appropriate security measures. Expect the personal information an organization holds about them to be accurate, complete, and up to date. Obtain access to their personal information and ask for corrections if necessary. And complain about how an organization handles their personal information if they feel their privacy rights have not been respected. Okay, let's do a Scrabble word and take a quick stretch. The word is awa, spelled A-W-A, and this means away or departed. Okay, let's move on. The law requires organizations to obtain consent when they collect, use, or disclose their personal information. Supply an individual with a product or a service even if they refuse consent for the collection. For example, if you go to the grocery store and they ask you for your postal code or zip code and you say no, they still have to cash you out. Use or disclosure of your personal information unless that information is essential to the transaction. If you're enrolling into a course online and they ask you for your driver's license or your health card information, that may not be needed for that transaction. Nor should they disclose that information to others if it's not necessary to that transaction. So think about when you're working with your clients. You may have information about them, but you don't necessarily need to disclose it if it's not essential to that specific situation. Collect information by fair and lawful means, and have personal information policies that are clear, understandable, and readily available. Your personal information includes your name, race, ethnic origin, religion, marital status, educational level, email address and messages, IP addresses, age, height, weight, medical records, blood type, DNA, fingerprints, voice prints, income, purchases, spending habits, banking information, credit and debit card data, loan or credit reports, tax returns, social insurance numbers, or other identification numbers. In Canada, any data, including users, statistics, and volume, must be available to the covered entity in Canada. That data is important in accountability procedures in cases of privacy violations. In addition, sensitive or personally identifiable information such as age, name, ID numbers, income, ethnic origin, or blood type, medical records, opinions, evaluations, comments, social status. The Act gives individuals the right to know why an organization collects, uses, or discloses their personal information. The Health Insurance Portability and Accountability Act of 1996, commonly known as HIPAA, is a series of regulatory standards that outline the lawful use and disclosure of protected health information. In the United States, HIPAA compliance is regulated by the Department of Health and Human Services and enforced by the Office for Civil Rights. HIPAA gives you rights over your health information, including the right to get a copy of your information, make sure it is correct, and know who has seen it. There are two components to HIPAA. There is Title I, which is Healthcare Access, Portability, and Renewability, and Title II, which is Preventing Healthcare Fraud and Abuse, Administrative Simplification, Medical Liability Reform. The purpose of Title I is to regulate the availability and coverage of group health plans and certain individual health insurance policies. For example, Title I limited restrictions that health plans can put on pre-existing conditions. The purpose of Title II is to identify rules and penalties for violations of rules that help prevent fraud and abuse in the healthcare system. Prior to HIPAA, no generally accepted set of security standards or general requirements for protecting health information existed in the healthcare industry. At the same time, new technologies were evolving, and the healthcare industry began to move away from paper processes and rely more heavily on the use of electronic information systems to pay claims, answer eligibility questions, provide health information, and conduct a host of other administrative and clinically based functions. Today, providers are using clinical applications such as computerized physician order entry systems, electronic healthcare records, and radiology, pharmacy, and laboratory systems. Health plans are providing access to claims and care management, as well as member self-service applications. While this means that the medical workforce can be more mobile and efficient, the rise in the adoption rate of these technologies increases the potential of security risks. This is the reason why we need to talk about proper storage, transportation, and destruction of documents so that we do not violate anyone's confidential information. So what is protected health information? Protected health information is any demographic information that can be used to identify a patient or client. Common examples include names, addresses, phone numbers, social security numbers, medical records, financial information, and full facial photos, to name a few. Protected health information transmitted, stored, or accessed electronically also falls under HIPAA regulatory standards and is known as electronic protected health information. Who needs to be HIPAA compliant? HIPAA regulation identifies two types of organizations that must be HIPAA compliant. Covered entities are defined by HIPAA regulation as any organization that collects, creates, or transmits protected health information electronically. Healthcare organizations that are considered covered entities include healthcare providers, healthcare clearinghouses, and health insurance providers. Business associates define HIPAA regulation as any organization that encounters protected health information in any way over the course of work that it has been contracted to perform on behalf of a covered entity. There are many, many examples of business associates because of the wide scope of service providers that may handle, transmit, or process protected health information. Common examples of business associates affected by HIPAA rules include billing companies, practice management firms, third-party consultants, EHR platforms, MSPs, IT providers, faxing companies, shredding companies, physical storage providers, cloud storage providers, email hosting services, attorneys, accountants, and many more. The HIPAA privacy rule sets national standards for patients' rights to protected health information. The HIPAA privacy rule only applies to covered entities, not business associates. Some of the standards outlined by the HIPAA privacy rule include patients' right to access protected health information, healthcare providers' rights to deny access to protected health information, the contents of use and disclosure forms and notices of privacy practices, and more. The regulatory standards must be documented in the organization's HIPAA policies and procedures. All employees must be trained on these policies and procedures annually, with documented attestations. The HIPAA security rule sets national standards for the secure maintenance, transmission, and handling of electronic protected health information. The HIPAA security rule applies to both covered entities and business associates because of the potential sharing of electronic protected health information. The security rule outlines standards for the integrity and safety of those documents, including physical, administrative, and technical safeguards that must be in place in any healthcare organization. Specifics of the regulation must be documented in the organization's HIPAA policies and procedures. The HIPAA breach notification rule is a set of standards that covered entities and business associates must follow in the event of a data breach containing protected health information. The rule differentiates between two kinds of breaches depending on the scope and size, called minor breaches and meaningful breaches. Organizations are required to report all breaches regardless of their size, but the specific protocols for reporting change depending on the type of breach. Let's do a Scrabble word and take a quick stretch. The word is LIS, spelled L-I-S. And this is a lawsuit. All right, let's continue. The BACB has its own laws and requirements. For example, the Code of Ethics talks about maintaining records, and it states that behavior analysts maintain appropriate confidentiality in creating, storing, accessing, transferring, and disposing of records under their control. Whether these are written, automated, electronic, or in any other medium, behavior analysts maintain and dispose of records in accordance with applicable laws, regulations, corporate policies, and organizational policies, and in a manner that permits compliance with the requirements of this code. The BACB also has a code that talks about records and data, and it states, behavior analysts create, maintain, disseminate, store, retain, and dispose of records and data relating to their research, practice, and other work in accordance with applicable laws, regulations, and policies, in a manner that permits compliance with the requirements of this code, and in the manner that allows for appropriate transition of service oversight at any moment in time. Behavior analysts must retain records and data for at least 7 years, and as otherwise required by law. The BACB requires documents to be maintained for 7 years and be in compliance with the country, state, or province that we're in. The BACB requires that behavior analysts appropriately document their professional work in order to facilitate provision of services later by them or by other professionals, to ensure accountability, and to meet other requirements of organizations or the law. Behavior analysts have a responsibility to create and maintain documentation in the kind of detail and quality that would be consistent with best practices and the law. So now that we have a foundation and we know of the basic requirements or need of requirements of the law when practicing, let's get into the basics of creating, storing, accessing, transferring, and disposing of records. Your responsibility as an RBT is crucial to ensure that files and documents are appropriately created, stored, accessed, transferred, and disposed of. So now that you have the information, what is your responsibility? We have laws, and it's important to know those laws. Learn more about PIPEDA or HIPAA whether you're in Canada or the US. If you're taking this course in another country such as Australia, France, Germany, or anywhere else in the world, please search your laws and know them to protect yourself and your clients. Let's talk about some of the general practices that are best used when storing, transmitting, or destroying files and documents. As an RBT, you may be responsible for creating documents such as session notes, ABC data. Your supervisor may be responsible for creating IEPs, behavior plans, programs, and protocols. These are specific to the client for their programming. This is a document that I use at the center with my team to track their hours of supervision time with me. You can create something like this so that you can track your supervision time with your supervisor. Things you discussed, whether it was an observation or a meeting, Remember, you can only do 50% meetings, so this will help you keep track of your hours, but it's also something that can be used if you were audited by the BACB. Certain documents that you may have on file for the client will have personal information which is held by the organization or maybe by you. This all depends on whether you are doing a home-based service or work for an organization. Certain information that is collected may be sensitive, and you may need to ensure that it is not readily available and accessed by others if it's not needed. For example, suppose you have learners' behavior plans, and on that plan, private information about a CAS call is on that document. You may want to ensure that that sensitive information is not seen by a placement student at your center. It's important to know that your organization may collect information about the client. Why is it collected? How do we collect it? And what do we use it for? You may not be the one collecting the information, but someone in the office or your supervisor may. You may be asked to collect that information on behalf of your supervisor. Imagine your supervisor asked you to speak to the parent and find out if Johnny has had any medical concerns in the last 6 months. You may just follow instructions and gather that information. However, that information is sensitive and needs to be protected. You may wonder why your supervisor needs it, or they may ask you to get that information because they need to add it to the behavior plan. So, when creating documents, session notes, or taking data for your client, it is essential that consent is obtained by the client or guardian responsible for that client. So what is consent? What is valid and meaningful consent? Consent is when the client gives you permission to gather information or use the information that is private or personal. Asking a client about their child's medical concerns may not be something the client wants to share with you, and they may not need to. I had a client that didn't want the entire center to know about their child's seizures. She requested that the information not be put on any behavior plan or IEP. I did receive consent to share the medical concern with his direct supervisor and lead therapist so that if an emergency occurred, we could use our emergency protocol. You want to be sure that your client understands the consent regarding the collection and disclosure of personal information. So be sure that consent is worded in a way that your client understands it. The wording is clear. When gathering information, you need to explain the purpose of the personal information being collected, used, and disclosed in sufficient detail for individuals to meaningfully understand what they are consenting to. The client also needs to know any risks of harm and other consequences that may occur with the collection, use, and disclosure of that personal information. Clients need to be aware that confidentiality may be breached in certain circumstances. For example, if CAS calls to gather information or there is a risk to life for the client and the police are contacted, that personal information may be disclosed. Going back to my client with the seizures, not sharing the fact that her son had seizures may put him at risk if the staff don't know of his condition. So it was more important that I made her aware of this and that having his direct team aware of his condition would be best for his safety. When collecting information, collect what is needed only. By reducing the amount of information gathered, you can lower the cost of collecting, storing, retaining, and disposing. But it also reduces the risk of lost information which would put you or the organization in. When storing information, follow policies that govern personal information within your organization. Be sure all information is up to date and accurate. Protect all information against loss, theft, or unauthorized access. Be sure to follow security safeguards within your organization. For instance, you may lock filing cabinets or restrict access to offices and so on. Be up to date with technological tools such as passwords, firewalls, and so on. Find out from your workplace how to store and share documents. Keep files safe and out of reach from visitors in a locked room or filing cabinet. Programs, graphs, and other data should be stored in a binder, clipboard, or in proper folders so it does not get lost or misplaced. Any notebooks with meeting information should be placed in a safe place that no one can access or read. Files on your desk should be put away when visitors come so that they don't read other clients' information. Laptops with confidential client information should be locked with a password so that if it's stolen or misplaced, that no one can easily access it. Avoid taking files home. If you have to store your files in your home, for example, if you run a home-based program, you may take files home, so be sure those files are in a safe place and locked up. You may also have to leave files at the client's home. Be sure they are placed somewhere where no one will take them or destroy them. It is your responsibility. If you have electronic files, same thing applies. Be sure they are stored safely. They may need to be password protected. If they're on a server, make sure that that's protected as well. Make sure your internet is protected, that is, secure, and that people will not hack into it. Same thing with your computer files. If someone gets into your system, they can easily get into your files. From time to time, you may be required to share information. Be sure you share information only to those you have consent to share with. You may need to ensure that they have the right to access that information. For example, if the school teacher calls you to ask about the learner's programming, you may need to ensure that the client or guardians have given you that consent to share. If CAS calls, most often they get consent from the guardian to speak with you. They will show you proof of that consent. Again, it's important to document the date of request and how to deal with that request based on your organization, policy, and procedures. You may share documents with other professionals. If you're doing so over the phone, again, be sure you have consent. If you're sharing it through email, be sure that it's password protected. Sometimes files are asked to be faxed over. Now, this could be a problem since you don't know who will actually pick it up off the fax machine, and it may get into the wrong hands or get lost altogether. For example, if you've ever bought a new car, the dealer will request that your insurance company fax over the policy to them. This happened to me, where my policy was faxed over several times, and it was either misplaced, no one picked it up, or the dealer just seemed to lose it. So you want to ensure that it's handed to the right person. Faxing, in this case, is not the best way to transfer information. Emailing is better because it's going directly to the person's email. I'll get into emails shortly. There are different modes of communication and transferring information. This can be done through emails, voicemail, texting, Skype, and so on. Always ask your client about the best form of communication that they prefer. Double check the contact information and make sure everything is up to date. All right, everyone, let's do a Scrabble word. The word is oca, spelled O-C-A, and it's a type of plant. All right, let's move on. When sending emails, they should be encrypted. Always send out an initial email to ensure you have the correct email address, and you should never put identifying information in that email. For example, don't say Johnny's report needs to be signed and the password for the document is popcorn1234. Rather, you should use initials in the email and never send the password of the file in the email, or at least the same email. You might tell them the password at the door verbally or text it to them or send a separate email with a password, but you don't need to specify what it's for or which document. When emailing clients, more than one client, be sure to use the BCC option so that the email addresses of your clients are protected. Some of you may be thinking, what about CCing a client instead? When using CC, all those in the email will see each other's attached to that email. When using BCC, no one can see the other's email. Therefore, you're protecting your clients. When sending a voicemail, never leave identifying information in the voicemail. Always double check that the information is up to date and ensure you have the correct numbers. With both voicemails and texting, if you've ever had anyone change their number on you and they didn't update you and you sent them that text or left a voicemail and you kind of told them everything in that voicemail or text, and then you get a response from someone who says, I'm sorry, you've got the wrong number, or I'm sorry, I'm not Johnny. Sometimes that can be a little embarrassing, but again, if you're sending out private information, then you may have revealed too many things to somebody that you shouldn't have revealed it to. So be very careful with that. So let's talk about texting. For texting, the same rules apply. Don't leave identifying information. Use initials only, and you can use texting to confirm appointments. I'm not big on texting clients. I prefer using emails or leaving a general voicemail to just call me back. When disposing of files or documents, be sure to follow your company's policies and procedures. It's best to destroy any personal information that the organization no longer needs. Limit and monitor access to personal information. For example, suppose you're working with a learner and a placement student is shadowing you. They may ask to look at the learner's behavior plan or IEP for a school project or assignment. You want to be aware that they shouldn't have access to all the information. You may have them look at parts of the document to do their assignment, but they shouldn't have full access to the document without your supervision. You need to ensure before destroying any file or document that you're following the retention laws of your organization, country, state, and of course, the BACB requirements. So the minimum is 7 years, but your organization may require that you hold things for 15 years before they're destroyed. Imagine your supervisor asks you to shred a document, but it's only been 3 years. Would you shred it? Well, the answer should be no. It doesn't meet the requirements for disposing both by the BACB and your organization. If you're disposing of documents, be sure you shred it. You should never just throw things out in the garbage with identifying information, or even if it didn't, it still should be shredded. Keep files safe and secure, never leaving things laying around. We covered a lot of information, really important information. Let's jump into the quiz. Good luck. Jenny is an RBT. She's required to do a school visit. She took Tommy's IEP to share with the school teacher. Tommy's mother has given consent for Jenny and the teacher to share information. Jenny left the IEP on the floor near the sand table while she walked around the classroom observing Tommy. What's the issue here? A, she didn't get consent. B, she put the IEP on the floor. C, she gave information to the teacher. D, all of the above. And the correct response is B, she put the IEP on the floor. Mike is an RBT. He has reports of clients in his file for over 15 years. In his current province, he is able to dispose of records after 7 years. Mike takes all his reports and places them in the garbage bin. What is the issue here? A, Mike should keep all reports just in case. B, Mike should have shredded the reports. C, Mike should have recycled them. Or D, there is no issue here. And the correct response is B, Mike should have shredded the reports. John is an RBT and works in a private center for children with autism. He attended a few school meetings for his student, Mark, and took thorough notes. After 3 months, Mark's parents pulled him out of the IBI services. About 2 weeks later, John shredded all his notes to protect Mark's private information. What is the issue here? A, John should have kept the documents longer. B, John should have kept the documents for 7 months. C, John should have recycled the documents. Or D, John made the right decision. And the correct response is A, John should have kept the documents longer. Remember, you need to keep documents and files for at least 7 years or as required by your province or state. What does PIPEDA stand for? A, Professional Information Protection and Electronic Document Act in Canada. B, Personal Information Protection and Electronic Document Act in Canada. C, Protocol Information Protection and Electronic Document Act in Canada. Or D, none of the above. And the correct response is B, Personal Information Protection and Electronic Document Act in Canada. What does HIPAA stand for? A, Health Information Portability and Accountability Act. B, Health Insurance Protocol and Analysis Act. C, Health Insurance Portability and Accountability Act. Or D, none of the above. And the correct response is Health Insurance Portability and Accountability Act. What is consent? A, when the client gives permission to gather and use private information. B, when the client does not give permission to gather and use private information. C, when a client's private information is used without informing them. Or D, none of the above. And the correct response is A, when the client gives permission to gather and use private information. Title I is A, Preventing Fraud. B, Healthcare Access Portability and Renewability. C, Healthcare Protection. Or D, none of the above. And the correct response is B, Healthcare Access Portability and Renewability. Title II is A, Preventing Fraud. B, Healthcare Access Portability and Renewability. C, Healthcare Protection. Or D, none of the above. And the correct response is A, Preventing Fraud. Which of the following is considered as personal data? A, ethnic origin. B, income. C, social insurance number. Or D, all of the above. And the correct response is D, all of the above. Documents should A, always be shredded. B, should be recycled. C, should be kept for 7 months. Or D, none of the above. And the correct response is A, always be shredded. Kate is an RBT and sends an email to a client's parents. The email states, Ryan is doing really well on his assessment. What is the issue here? A, Kate should not be using her learner's name. B, Kate should verify the email address before sending the email. C, Kate should review her learner's assessment over the phone. D, none of the above. Or E, A and B only. And the correct response is E, A and B only. Jenny is an RBT and took all her clients' documents and threw them in the garbage. What is the issue here? A, the paper will get crumpled. B, the documents should be shredded. C, the paper should be recycled, or D, nothing is wrong here. And the correct response is B, the documents should be shredded. Abby is an RBT. She's out getting some coffee on her way to work when she bumps into her learner's teacher. They engage in conversation and she says, "Yeah, Johnny just moved to 23 Baker Street to be closer to our center." What is the issue here? A, Abby should not have stated her learner's address. B, Abby should not risk being late for work. C, Abby should have gotten consent to discuss the learner's information with the teacher. Or D, both A and C. And the correct response is D, both A and C. Now, we want to get consent before we share any type of personal information. Even if it's with a teacher, that's okay. But she should not have stated the learner's address. And another thing is, you really shouldn't be stating a learner's address or any private information in a public setting. So the violation is she shouldn't be talking about private information in a public setting. So saying his name and his address, things like that. Jess is an RBT and makes a phone call to a learner's parent. The parent does not pick up and Jess decides to leave a voicemail and mentions the learner's personal information. Turns out Jess had the wrong number. What is the issue here? A, she should not have revealed personal information in the voicemail. B, she should have checked the number first. C, this was an honest mistake. D, all of the above. Or E, both A and B. And the correct response is both A and B. She shouldn't be revealing information in the voicemail, and you should always keep your information updated, so check the number first to make sure that it's updated. And again, don't leave personal information on voicemail. Sarah is an RBT. After a month of working with a new learner, the parents decide to move him into another center. A couple of weeks later, Sarah shreds the learner's documents and could not share the information with the parents when they requested it. What is the issue here? A, it has not been 7 years. B, she should have recycled the documents. C, she should have given the documents to the parents when they left the center. Or D, there's no issue here. The correct response is A, it has not been 7 years, so she shouldn't have shredded the documents because, of course, the parents may ask for those documents when they leave the center, and so you would supply them with that information if they had required it. Carl is an RBT and decides to send an email to his clients. Instead of sending them individually, he decides to CC everyone in the email. What's the issue here? A, he should have sent each email individually. B, he should have used BCC instead. C, he should not be sending emails to his clients and should schedule meetings instead. D, there is no issue here. So the correct response is he should have used BCC instead. Now, of course, you can send the emails individually, but if you're saving yourself some time and you need to send a group email to a lot of the parents, then, of course, BCC would be the better option. Luna is an RBT and was sending an email to her client, giving them access to a private file about their child. The email stated, "The password to the document I have attached to the email is Behavior for Life. The information provides your child's name, age, home address, medical records, school records, and so on." What is the issue here? A, Luna should not have revealed what was on the document. B, Luna should not have sent the password in the same email. C, Luna should have made sure to get the right email first. Or D, all of the above. And the correct response is D, all of the above. You're an RBT. You find out your learner has a medical condition that the parents have not shared with the rest of the staff. So you decide to go ahead and tell your team about it instead. When your client finds out, they get furious. Why might this be? A, the parents are just having a bad day. B, you did not get consent to share this information. C, the team has a right to know. D, they just don't like you. And the correct response is B, you did not get consent to share this information. Well done. Okay, my final thoughts. Be sure to document your session, hours, ABCs, collect data, and other important tasks that an RBT is required to do. You also want to ensure that you're protecting your client and their information. You would never want your doctor to release your private medical records to anyone or share them with anyone. Whenever you're doing anything for your client, always think of protecting them, protecting their information, and protecting their files. It's not our information to share. You shouldn't go home and talk about little Johnny and his programs with your family members or friends. You should never share their pictures or private information on social media. We'll get into that further when we discuss ethics. I want to thank you for joining me today, and we'll see you next time.